There can be a law for even one individual. How to test the validity of classification? How this validity of classification can be checked? Firstly, it must be reasonable. It must be based on intelligible differentia. It must have rational and lawful objective to achieve. Example, minors contract. According to this, the minors are favored in the law of contract, but on the principle of equity, because minor doesn't have that prudent mind to think about his or bad or good. The classification is permitted when need not to be based on mathematical necessity. Classification need not to be scientifically perfect or logically complete. No need for identical treatment. Presumption in favor of constituency of law. Burden of proof on one who challenges classification. Examples of classification. There are valid classifications taking over the management of a company, special code for certain crimes, capitation fee for non-resident Indian candidates. Because new concept of equality. The new concept of equality has emerged over years. That equality doesn't mean sameness. The equality is a dynamic concept and cannot be cribbed, cabined, and confined within traditional and doctrinal limits. Right against arbitrariness, not enough to have reasonable classification or rational object. For example, triple talaq case law judgment struck down as invalid because it was arbitrary. Prohibition of discrimination on certain grounds, that is given in Article 15. Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. This strictly says that on these grounds, the discrimination or the classification is not reasonable, it is not acceptable, it is against the law of equality. According to Article 15, the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth. No citizen on these grounds be subject to any disability, liability, or restriction with regard to access to shops, public restaurants, hotels, and places of public entertainment, or the use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly out of state funds or dedicated to the use of general public. According to this article, that any person who is of irrespective of any religion, based to any caste, he belongs to any caste, whether a male, female, or a transgender, or belongs to any place of birth, should not be discriminated in the eye of state and in the public places especially. And other provisions of this is, according to Article 15 Clause 3, special provisions for women and children should be made by the state. That nothing in this article shall prevent the state from making any special provisions for women and children. As discrimination on the ground of sex is prohibited, but the women and children are those people who have been discriminated since so long. They need special care. That's why the special provisions the state can make for them. There are many laws related to child labor, education for children, women's right. According to clause 4, it was added by the constitutional amendment 1951, that was the first constitutional amendment, that nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provisions for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste and scheduled tribes. Special provisions for the advancement of socially and educationally backward classes of the citizens or scheduled class and scheduled tribes. These scheduled castes and scheduled tribes have been discriminated and have been suffering from since so long. They are very backward. They are not fully developed. They don't have each and every privilege to get education and to be socially fit. So the state can make any special provisions for them. And Article 29, that is related to education for minority, cannot stop the state for making any special provision for socially and educationally backward classes or for the scheduled caste and scheduled tribes. And according to clause 5, nothing in this article, there are, when this clause 4 of article 15 was passed, there were certain problems which were raised in the then Madras province of British India. The communal geo that provide opportunities to the oppressed communities in the state services and state educational institutions were implemented since 1928. Even after independence, the effect of communal geo was amplified by providing due representation to the various oppressed communities, including the backward classes. When the Indian Constitution came into force since 26 January 1950, the communal geo was challenged in the Madras High Court on the ground that geo discriminated the citizens based on the arguments put forth by the petitioner side. The High Court held that communal geo is invalid. On the appeal made by the State of Madras, the Supreme Court upheld the verdict of High Court, State of Madras versus Champakam Dorairajan 1950. Despite the fact the petitioner, a Brahmin lady, had stated that she didn't get the opportunity to pursue the medical degree course in the government medical college, but the fact was that she did not apply for the courses at all. Thantai Periyar started massive agitation in the Madras state and revolted against the verdict of the judiciary that denied social justice to the historically oppressed people who were denied of educational opportunities. The revolt, with the support of marginalized masses in the multitude, became unabated. Recognizing the justification of the revolt, Article 15(4) was inserted into the Indian Constitution through the First Amendment in 1950. Through this case law, by the verdict of Supreme Court, and after the revolt, after thinking that all this is justified, the Article 15 Clause 4 was added by First Constitutional Amendment in 1951. But later on, it was challenged on various. According to Dr.